Hi, everyone. Welcome to another enlightening episode of the Canadian SME Small Business Podcast. I'm your host, Maheen, and today we have an episode packed with valuable insights. We'll be diving into the Working for Workers legislation and its implications for small and medium enterprises. Our guest today is Paulette Haynes, a seasoned employment lawyer and the driving force behind Haynes Law Firm in Toronto. With a career spanning over 2 decades, she has established a reputation for providing strategic legal counsel to both employees and employers navigating complex workplace issues. Her expertise extends beyond the courtroom, as evidenced by the authorship of Human Resources Guide to Non-Standard Employment and her former roles as a university professor and adjunct legal studies professor. So join us as we explore her insights on the recent legislative changes and their impact on SMEs. Hello, Paulette. It's a pleasure
Hello,
to have
Maheen.
you
Thank you
back.
very much for that very warm and generous introduction.
Oh, always. I mean, there's always something new, and we're so excited to have you back to have our readers hear more about your extensive experience in the employment law. And again, I mean, your commitment to supporting both groups, the employees and employers, is incredibly valuable. So we're very thrilled to have your insights being shared with our audience today.
Thank you so much.
Now, Paula, to begin things with, the Working for Workers legislation has, kind of introduced significant changes in the workplace. Could you please provide a brief overview of the key changes introduced by this legislation series?
Absolutely. Thank you. Great question. So, if we can go back a little bit in COVID, in about October of 2021, the Ontario government introduced legislation with a view to better supporting, protecting, and attracting workers to Ontario. And the legislation in question at that time was the Working for Workers Act 2021. And the goal there is that through that legislation, the Ontario government was hoping to, promote about a healthy work-life balance, to foster a competitive environment in Ontario by banning non-competition provisions and agreements. And I think everyone knows that the COVID-19 pandemic has really been a game changer. Amongst other things, it has changed fundamentally how a lot of us work. But it's also left a lot of people struggling individually in terms of meeting their own individual needs and those of their families. So what the Ontario government has endeavored to do is pass a series of legislation. And each piece of legislation really seeks to address the various contemporary issues in Ontario's workplaces.
Right. I mean, the overview gives us great foundation to understand these legislative changes. And on that note, I really want to connect with our listeners here as well, because listeners, understanding the Working for Workers legislation is so crucial for everyone, especially the small business owners. And these changes can have, significant impact on how you manage your workforce and stay compliant. And it's so essential to stay informed and proactive, as this legislation could influence many aspects of, your business operations. So please make sure that you're taking the necessary steps to stay adapt and thrive in this evolving landscape.
Absolutely.
Now, Paulette, Bill 149, which is Working for Workers for Act 2024, brings several amendments to the Employment Standards Act. Can you please elaborate on the most significant changes to the ESA brought about by the Bill 149?
Absolutely. Great question. So, Bill 149 is one of the latest series of legislative initiatives by the Ontario government under that Working for Workers banner. And while, like its predecessors, Bill 149 has amended a number of pieces of legislation, as you rightly point out, the Employment Standards Act being one of them. And I think the changes to that legislation is of particular noteworthiness to small and medium sized enterprises. And I want to identify four key ones that are, for the most part, enacted, and to which I think CMEs, small, medium, and enterprises will want to take attention to in the now. First is about trial periods. So the Employment Standards Act has been amended such that workers who work under a quote unquote trial period are now considered to be employees under the legislation. What does that mean for small and medium sized enterprises? Well, that means that those workers attract some of the protections of the legislation, such as minimum wages, hours of work over time. So our SMEs are really going to want to be mindful of those obligations, right, as it relates to those kinds of workers.
Hmm.
And that provision took effect as of March 21st of this year. Secondly, as of June 21st of this year, we have changes to vacation pay. So under Bill 49, the Employment Standards Act has now been amended such that if employers want to pay their employees vacation pay in a manner other than what I'm going to describe as the default provision, that is to say, typically what the current regime requires is that employers pay their employees a lump sum for vacation pay in advance of taking vacation. Now, the reality is that a number of employers paid their employees vacation pay in a manner other than an alternative method. For example, either during the course of that employee's vacation or as a percentage of their wage, and it's reflected in the pay statements, assuming, of course, that the employee consents. What Bill 149 does now is that it imposes the requirement that if an employer wants to pay vacation pay, other than in the default method, that is to say, a lump sum in advance of vacation, that alternative payment method has to be memorialized in a written agreement between the employer and the employee. And the timing of those vacation pays also have to be confirmed in writing as between the employer and the employee. Thirdly, what the amendment to the ESA relates to tips and gratuities. So under Bill 149 now, employers can pay their employees gratuities and or tips by way of cash, check, assuming that check is made payable directly to the employee, direct deposit, etc. And there are specific rules around how those payment methods are to be executed. So for example, if you had a small, medium-sized enterprise that wanted to pay their workers tips by way of direct deposit, there are certain requirements, such as the employee has to identify the account to which the tips will be paid. That employee's account has to be solely that employee's account. It's not paid to any other account. And that employee must have access to that account, save and except for if there's some other authorized person to that account, right? So there's specific rules with regards to that. Also, if the employer engages in what's known as a tip pooling policy, where tips are split between the employer and the employee, Bill 149 is now going to require that the employers post and keep posted those policies, and they must be displayed in the workplace, in at least one place on the work premises, where it can be brought to the attention of all the employees. And the
Hmm.
bill further requires a retention obligation that the employers retain those policies for a period of 3 years, even after the policy is no longer in effect.
Right.
But I think the most impactful of the changes to employment standards as it relates to Bill 149 is going to be the rules around job postings. Now, with that said, a couple of things. Those rules have not yet been enacted. I fully expect that in some months to come, the government is going to let employers know when those new rules come to effect. And I expect that there'll be some clarifying legislation with regards to those new rules. So for the time being, it appears that what I'm about to say with respect to job postings will not take effect yet until the regulations come into play. But with that said, I think our SMEs should anticipate that very soon they're going to have to revisit things like their recruitment strategies, their documentation with respect to disclosure on compensation, use of EI, requirements around Canadian experience, and so on. As it stands right now, Bill 149 is looking at three key changes as it relates to job postings. One is where the expected compensation or the expected pay range will have to be included in the job posting.
Hmm.
Second of all, if the employer is using artificial intelligence, AI, to assess, select, recruit candidates, that will have to be included in the job postings. And thirdly, employers will be prohibited from including requirements related to Canadian experience. And that prohibition is going to apply not only to job postings, but to the application forms as well. So those are some of the things that are already in the works for the most part under Bill 149.
No, it's very crucial for SMEs to be aware of these changes to really stay compliant and competitive. Now, Bill 190, Working for Five Act 2024, is introduced with, to new rules and around job applications and sick leave. Paulette, what are the key changes proposed in Bill 190 related to job applications and interviews?
Great question again. Now, first thing I guess our audience should know is Bill 190 is not yet law. It was first introduced in the legislature in May of this year. And as I understand it, this bill is now subject to public consultation. So it's still in the lawmaking process, if you will. But I think there are a couple of changes, proposed changes that SMEs are going to want to be mindful of. First of all, are those changes with respect to job applications and interviews, and secondly, the requirements of employers with respect to sick leave. So first, as it relates to job applications and interviews, what Bill 190 is proposing is that if a job posting, a publicly advertised job posting, is related to an actual vacancy, that needs to be stated in the job posting. Now, you may say, well, that almost sounds redundant, but what the government is trying to get at is a practice where job postings have been made primarily for the purposes of surveying the labor market to see what's available as opposed to actually filling a job position. Further to that, under Bill 190, when a candidate actually does an interview, the bill is going to impose a requirement on employers to provide the candidate with certain information within a stipulated period of time as it relates to that interview. And that information that's disclosed to the candidate has to be retained by the employer for at least 3 years after that information has been disclosed. So
Hmm.
that's one. Secondly, under Bill 190, it relates to the amendment relates to sick leave and what employers can ask in terms of evidence. So under the current regime right now, if you have a worker who's been working for an employer for 2 consecutive weeks, they are entitled under the Employment Standards Act to sick leave, which works out to 3 unpaid days per calendar year for personal illness, injury, emergency. And in that context, of course, an employer can ask for evidence, right, which is reasonable in circumstances to support the leave. What Bill 190 is proposing is to prohibit employers from requiring that a worker provide a certificate from a quote unquote qualified health practitioner with respect to their leave. So I think in terms of the go forward, again, Bill 190 is still a lawmaking process, but if it does pass through all the stages and does get proclaimed, then I think employers, SMEs in particular, can expect that they're going to maybe have to modify what they can expect in terms of what they can ask their employees when they are trying to engage that sick leave policy.
Right.
The third thing I would say, though, is penalty provisions are also anticipated under Bill 190 for individual violations. So where an employer, for example, violates on an individual basis the Employment Standards Act or does not comply with orders from the Ministry of Labor, they could be looking at fines as large as $100,000.
Mm-hmm. No, understanding these implications really helps SMEs prepare and adapt effectively. Now, let's learn a bit more about the impact on SMEs, since adapting to new legislation can be challenging for a lot of them. Paula, what steps should SMEs take to ensure compliance with the new legislation?
Great question. And as you rightly point out, sometimes SMEs can be taxed, right, by keeping up with the legislation. And suffice it to say, since COVID, there's just been a myriad of changes, even as Employment Law Counsel, that we have to be busily keeping up to speed on. But 2 things I would put out to Canadian SMEs in terms of how to comply with the legislation. One, SMEs should ensure that to the extent that amendments have taken effect already, they need to now ensure that they comply with those pieces of legislation. So I've talked about, for example, the trial periods, the vacation pay. They'll need to maybe scrutinize and revisit their practices in that regard to make sure that it's now in compliance. You think, for example, about vacation pay and the method of payment. SMEs should start to review their employment agreements to see if those agreements speak to alternative methods of paying the vacation other than the default method. Because if they're silent on that point, then generally speaking, they can't actually pay the vacation pay in those alternative methods. Now, with that said, the question would be is, do they need to maybe revisit the arrangement, perhaps have standalone agreements drafted if their intention is to continue the alternative pay arrangements? So again, I would encourage SMEs to get up to speed on the amendments that are in effect, and there have been a number of them that I've identified today that are already enacted. Already the governments are expecting employers to comply. If need be, reach out to employment law counsel to assist in making the adjustments so that they're in compliance. But the second thing is, I'm going to encourage SMEs to wait and see, to really actively be on the lookout for further changes, both under Bill 149 and Bill 190. Now, Bill 149 has a lot of amendments, proposed amendments, so it is law, but I think we're going to see in the coming months the Ontario government announce regulations clarifying the rules and the ways in which to execute the new rules. But again, I would encourage SMEs to revisit their practices, particularly as it relates to recruitment, in terms of, again, documentation, retention, the use of AI, because what is coming down the pike will require them to make those changes. And ideally, SMEs want to be in a position of readiness so they can really use this time now, even though some of those changes have not yet taken effect, to start to review their recruitment strategies, practices, et cetera, to get them ready for what eventually will be coming.
Mm-hmm. No, it's really reassuring to know that there are steps available to aid compliance. But Paulette, are there any resources or support available to help SMEs navigate these changes?
Not at the present time. And again, it's because the legislation is so new. I mean, one can always, I guess, refer to the Ministry of Labor and so on. But again, until I think we have those clarifying pieces of legislation, it will be difficult, I think, challenging to find those supports at this point in time. So again, I would
Right.
reiterate, employers, please get up to speed on the changes that have taken place, consistently be on the lookout. And again, I know that SMEs are taxed with so many different things that these legislative changes are additional to that. This may be an opportunity where an organization may want to reach out to employment law counsel to assist them to keep up to speed on the changes that are in effect and are coming.
Right. No, navigating new legislation can often feel overwhelming, but it's really important to remember that, there are resources and steps available to help small businesses ensure compliance. Listeners, please embrace these changes and as opportunities to improve your own business operations by staying informed and taking proactive measures. You can really turn potential challenges into advantages, and ensuring, your business not only adapts but thrives in the face of new regulations. So let's view these updates as a chance to enhance our practices and grow stronger together. Paulette, staying ahead of legislative changes is vital for SMEs, and it's something every business owner needs to be proactive about. What can we expect from future working for workers legislation?
Great question. So, in the near future, I would encourage SMEs to really turn their minds to some of the things I've commented on because changes are going to be coming on a number of items. So, let's talk first about artificial intelligence. Um, this is again under Bill 149. The legislative framework is there, and employers can expect that they will be required, to the extent that they're using artificial intelligence in their recruiting practices, they will be required to post that usage in their publicly advertised job postings. And Bill 149 has already contemplated in the legislation that terms like artificial intelligence, like publicly advertised job postings, should be defined by regulation. Again, that's coming.
Mm-hmm.
Secondly, the Canadian experience job requirements piece. Again, under Bill 149, the law is already set. And so, what we can expect, subject to clarifying regulations, is that employers will be prohibited from requiring job requirements related to Canadian experience to be posted in their job postings and in their application forms. I anticipate there will probably be some limited exceptions. We don't know what those are yet, but I expect that if there are exceptions, they will be expressed in the regulations. Thirdly, pay transparency. Again, employers who will be required to post the compensation ranges as expected, or the expected compensation pay with respect to the publicly advertised job postings in their job postings. Again, it would suggest that our SMEs should really start to, in the now, if you will, start to look at their recruitment practices, look at the documentation that they have supporting pay compensation and the disclosure thereof, because they again will be required to post that information in their job postings going forward. And then, of course, we have the retention policy and what I would say, or the retention requirement of all of these practices, policies, disclosure of information. Just think simply 3 years, 3 years from the time that you post these postings, use this information, employers will have to retain those informations for 3 years, even after the posting has expired. Again, the legislation, we don't have a lot of clarification yet on some of these things, but as you rightly point out, if CMEs can do what they can to keep informed, by that way they can keep ahead of the curve.
Mm-hmm.
Typically, once regulations are passed and declared and the government gives us more information, I fully expect some of the supports that you alluded to, those will come into play as well.
No, staying informed and proactive is key for SMEs to navigate future changes successfully. But before we wrap up, Paula, what is one piece of advice that you'd like to give to small business owners to help them navigate these changes effectively?
The big piece of information that I would, or advice that I would give to SMEs, is to seek help, seek legal help, make sure that you're well informed. I know it's very difficult for business owners to be keeping up to speed on all of this stuff and managing their businesses and dealing with the different facets that they have. And so I think it's reasonable to expect that employers, not all employers are going to have the bandwidth to keep up to speed on themselves. But this is where I think reaching out in terms of legal support, as in proper legal advice, if one can participate in HR workshops, even podcasts like this that provide information, right, in a brief and concise sense, to just constantly keep themselves informed and seek that support so that they can keep informed, would be my best advice to SMEs at this time.
No, thank you so much, Paulette, for coming in again and for sharing invaluable insights and updates and your expertise with us today. Again, thank you for your time.
Thank you so much for having me.
And listeners, that was the end of our discussion with Paulette Haynes, to whom we'd like to extend our gratitude. We hope that this episode equipped you with all the invaluable insights as we discuss the key changes in the Working for Workers legislation, the specific impacts on SMEs, and practical steps for compliance. We'd also like to extend our gratitude to our partners: exclusive banking partner RBC, shipping partner UPS, email partner Constant Contact, and hospitality partner IHG Business Edge for their support. Again, thank you all for tuning us and joining us today. Remember to subscribe to the Canadian SME Small Business Magazine by visiting our website, canadiansme.ca, to stay updated with more insightful episodes. And again, keep supporting local businesses and please continue to thrive in the world of small businesses. Thank you.